Hold up, grab my soda, cause I told you I'm colder than hell. I ain't buying what you sell, it don't ring my bell. Unless it's got the smell, you know, like grape pape. We ain't talking vapes or the color of drapes. Or a gorilla in a cape is the good shit. Just one hit, you so lit, you fall into a bit, non-bit. What's fucking funny is you're a monkey, a high school flunky, hero and junkie, obliteration of the carnation with gross castration, skewed citations by your intimations. Get real, young man, there's only one stand. You can't stand a suntan, how you gonna live on the land? Obliteration of the carnation with gross castration in skewed citations by your intimations. I'm a truth in rotation, you're a cheap imitation. Dark said hums, 808s make the ground shake. Cold as the grave, every word's a land quake. You're a flicker in a cipher, I'm the flame that won't fade. Step into the night where the shadows are made. What's fucking funny is you're a monkey, a high school flunky, hero and junkie. I'm gonna click another hit of this good shit, and I'm already it, so take over, it's been non-bit.
Thank you for joining us at Personality Inventory Mockumentary Productions.
Greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Want to remind everybody, hit that like, share, and subscribe button. There is a PayPal link down there for anybody that would share some love. Always appreciated. Going through some difficult times here, and things are kind of tight now. Just dropped almost $5,000 to do this move and everything. And we're going to go over a situation that is kind of redundant and people don't realize it sometimes. So I'm going to point it out. Kind of like in one of my earlier videos when I pointed out how the police came for disorderly conduct. And then instead of finding any cause or issuing a disorderly conduct to either myself or the upstairs tenant, they walked away saying they saw no clear and present danger. And the officer got on the stand and testified to this. And the problem with that is that when they walk away not finding the charges, they go back, they go right on to the next call or whatever. They don't make a police report. They don't make any service notes. So they're left up to just their memory if you call them back to the stand. Now, we call them back relatively quickly. You know, it was within like a week and a half, 2 weeks, week and a half. And in that, no, it was 4 weeks, because they came on the 24th. We had court on the 26th. So 4 weeks, almost 5. And he couldn't remember a lot of the things that we had discussed. And this is the importance of creating that record and that paper trail. So that's what we're going to talk about tonight with this dismissal. Most people would think it's a good deal. You got a dismissal. You should be good with it, right? Well, the problem with that is that the dismissal was handed down by the plaintiff. And if you remember, the hearing was held on the 26th, and the magistrate said that they were going to take it under advisement. And I was fully expecting to get the dismissal, but I needed it from the magistrate. I needed the magistrate to read into the record the findings of the facts and conclusion of law. And so by the plaintiff dismissing it herself because we moved. We were trapped in a hazardous, chaotic environment, and the bad faith of the property management. So like I said before, whether we got a dismissal or were evicted, we were going to be moving either way. We couldn't stay there. So the landlord or the property manager thought it'd be wise to go ahead and just dismiss it now that she doesn't have to worry about the forcible entry and detainer. The problem with that is, again, it cuts down the paper trail. In other words, the judge doesn't read into the record the findings of the facts and conclusion of law, and therefore it kind of goes as a blank slate, saying that we didn't do anything wrong, but neither did the landlord, right? So we want that statement in, on, and for the record, because that's what supports our civil rights claim. So I've got a document I'm going to pull up that we prepared. She did this yesterday, and I was hoping we'd be able to get it done today, but the internet didn't get hooked up until today, late this afternoon. So, but I did get it done, and it is drawn up, and we're going to take a look at this bad boy. And of course, as always, in the Iowa District Court for Blackhawk County, MGT Property Management Company plaintiff versus Keith Little and Joyce Schmidt defendants. And it was a small claims number. So it's still in the small claims, but our next move is to take it to the district court for a civil rights violation. But we can't do that without the findings of facts and conclusion of the law. We would essentially have a baseless claim. So we're going to make a motion to enlarge findings, which is to open the case and have her read that facts and findings and conclusions of law into the record, as well as which is a request for judgment on the merits. Same thing. We're going to request it for judgment on the merits to be the facts and findings, or the findings of facts and conclusion of law to be read into the record, so that it is recorded, that there is a valid paper trail showing the bad faith, multiple instances where she failed to give a cure, and request for production of documents. Because as I said, we found out that for the local municipal rental properties, they're supposed to be registered. And she was operating as a property manager for that property from December 1st until December 19th without the proper registration. So I don't know who else gets away with the law, but I know I'm supposed to do certain things before I can operate a motor vehicle. It's the same thing. Okay. So it comes now, defendants Keith Little and Joyce Schmidt, and respectfully moves this court to enlarge its findings and enter a judgment on the merits pursuant to Iowa Rule of Civil Procedure 1.9042 and Iowa Code 631.11. And you can look those up if you want. It'll tell you, and all states will have the same thing. So if you punch that wording, the verbiage into your search engine with your state, it should tell you which rule and which code they're talking about. Defendant further issues a formal request for production of documents to determine the plaintiff's legal capacity to have initiated this action. This is questioning jurisdiction. Necessity of judgment on merits. Okay. Constructive eviction. While the plaintiff seeks a dismissal based on the defendant's vacation of the premises, this move was not voluntary. Equity does not aid a volunteer. It was a constructive eviction necessitated by the plaintiff's bad faith and refusal to accommodate a known disability. Inadequate relief. A simple dismissal fails to make the defendants whole. The defendants were forced to provide their, you'll have to excuse me, sometimes I do this thinking about myself when it's actually me and my companion. And words have meanings, so were forced to provide their own cure, which was moving. under the duress of an illegal lawsuit, while the plaintiff remains unpunished for its admitted ignorance of the law. Capacity and standing. Defendant asserts that the plaintiff, MGT Property Management, lacked the legal capacity to bring this suit. They came with hands as dirty as our fucking furnace filter. They did not fulfill their strict statutory duty first and foremost, and came forth under the equitable action seeking a cure themselves. You can't dismiss a cure that somebody else requests and then seek a cure yourself by blaming that person for making a complaint. Under Iowa law, that's retaliation. Under Iowa Code 543B, property management is a regulated activity. Plaintiff's unclean hands operating potentially without licensure or in bad faith precludes them from seeking equitable relief. Requested findings of fact and conclusions of law. Defendants request the court to read the following into the record to support a valid civil rights claim. Fact. The property manager admitted under oath they failed to issue the mandatory 7-day notice to cure required by Iowa Code 5.628.271. Fact. The plaintiff was formally notified of the defendant's noise complaint, yet refused to provide the statutorily required 7-day notice to cure to the offending tenant. Conclusion. The plaintiff failed to meet the jurisdictional prerequisites to file this suit, and the defendant's departure was a direct result of the plaintiff's breach of the Iowa Civil Rights Act. Request for production of documents to establish a pattern of practice for the subsequent civil rights claim. Defendants hereby request the plaintiff to produce the following within 7 days. Professional licensure, a copy of the Iowa real estate firm license for MGT Property Management, and the individual broker license for the manager of record. Corporate status, a certificate of good standing from the Iowa Secretary of State, and management agreement, the contract between the property owner and MGT to verify MGT's legal authority to act as an agent in this jurisdiction. Now, what this does is I'm going after the landlord, because ultimately the landlord is liable as well. Culpability. If he has this same person doing the same thing for 8 years, and they create the same victims by their same ignorance of the law, then the landlord should know of that. That's why I'm doing this. I don't want the current landlord to undertake a property manager that I know is acting in bad faith and is displacing many living souls from their rightful peace. The Waterloo Property Rental Registry indicating that S.W.A.P was in fact operating as a rental property manager from December 1st until December 19th without proper registration, in fact, is available freely. Under Iowa law, when a tenant is evicted within 1 year of any complaints, there is a presumption of retaliation. S.W.A.P commenced eviction proceedings within a month, seeking equitable actions, though her hands are as dirty as our furnace filter. Conclusion. The cure in this case is not the defendant's move. Us moving is not the cure, but the statutory education or removal of a property manager whose pattern of practice creates victims out of the low income and disabled classes. Findings of fact are necessary to prevent a recurrence of this bad faith conduct. Wherefore, defendant requests the court reopen the record, enter the requested findings and conclusions, and compel the production of requested documents. I think it's pretty clear cut and dry there. These people have no right to be bringing this claim. They know it. Me and my companion have given them many graces along the way. We've given them notice in private. We went to a second witness in private, Listy Wickham. We gave the upstairs tenant a notice. We gave Listy Wickham a notice. That wasn't good enough. We were trapped in an environment of our own means, so things escalated. Another neighbor gave them notice. They didn't listen. Another neighbor called the police and gave them notice. The police contacted the landlord. The landlord contacted the management company. So they got notice that way as well. At least they should have. So all these notices, and she admitted on the stand that it was an ongoing situation between myself and the upstairs tenant, that she didn't know that she was supposed to give a 7-day notice to cure, and that she didn't do that, and that she's been doing this same thing, property management, for 7 years, not knowing her obligation, her strict statutory obligation to do so. I wonder how many victims there are, and I want to make sure there's no more victims in the future. So in order to do that, I cannot allow this dismissal the way it is. I must bring forth that findings of facts and conclusions of law from the magistrate to give the merits to the case so that it can move forward in the truth, letting no tongue prosper against those that would rise up in judgment, those false judgments. I shall condemn them. And if I don't address this, then I don't condemn it. I just let it go by the wayside. I have to condemn it. So I hope everybody understands that. And we're going to let you know how it goes. I'll file it tomorrow, and we'll wait to hear from them and see what they say. Like I said, I'll keep everybody up to date with this. And again, hit that like, share, and subscribe button. There's a PayPal link down below for anybody who wants to share some love. Always appreciated. And of course, like I said, we're cutting things tight right now because of everything we had to drop. So everything is most assuredly appreciated. In the meantime, remember, I speak because I have a right to, but exponentially, you have a right to know.
Beneath the pines where the red clay cries, a preacher's words cut through the lies. With a Bible worn and a rifle tight, we march where the tyrant's shadow bites. Oh, freedom's flame burns through the night, a rebel yell for the righteous fight. Break the chains, let the truth be sworn, from dust and blood a new dawn's born. The widow sows seeds in her husband's field, her tears baptize the ground they'll yield. A soldier's ghost hums an old hymn's tune, we'll cross that river for the blood dark moon. Oh, freedom's flame burns through the night, a rebel yell for the righteous fight. Break the chains, let the truth be sworn, from dust and blood a new dawn's born. When the thunder roars and the levee breaks, we'll plant our flag where the despot shakes. Through fire and flood, we'll hold the line, for peace ain't bought lest we dare to climb. Oh, freedom's flame burns through the night, a rebel yell righteous fight. Break the chains, let the truth be sworn. From dust and blood, a new dawn's born.